asking telecommunications providers to essentially turn over a large amount of data that they held on their users directly to the intelligence agencies, who would then store that data and access it based on some internal controls, but essentially as they saw fit.
We did all that democratic debate, and yet you're saying, regardless of all that, which all happened in the 2000s, nonetheless, in secret, they were going around that entire debate and getting the data anyways. Welcome back to The Technology Pill, a podcast that looks at how technology is reshaping our lives every day and exploring the different ways that governments and companies use tech to increase their power. My name is Gus Hossain, and I'm the Executive Director at Privacy International. And we're back from our break and back to our usual schedule of every other Friday releasing these podcasts. And this time, we're back with the closest thing to breaking news I think we've ever had on the podcast, which is to say, it's now 3 days out of date by the time you're getting this. To give some context, this past Tuesday, which was the 6th of October 2020, the EU's top court, the Court of Justice of the European Union, issued its judgment in 3 cases. One from the UK, where Privacy International is the sole claimant, one from France, where PI had also intervened, and one from Belgium. I'm here with our fantastic legal director and general counsel, Caroline Wilson-Palo, to talk about what happened. Okay, and just to be clear to everybody listening, as Caroline knows far too well, I'm not a lawyer. And so I am also trying to make sense out of everything that's happened in the past week. And I'm very much looking forward to Caroline helping me and everybody listening navigate all of this. So, Caroline, first of all, welcome.
Thank you. Yes.
Second of all, what was this ruling all about, and why was everybody making so much noise about it?
Well, the most important aspect of this ruling is the CJU made really clear that for the first time that even when countries are engaging in data collection for national security purposes, EU law applies. So that was sort of the major victory for us coming out of this judgment, was that the EU law will, and the fundamental rights that are enshrined in EU law, which are protections of privacy, data protection, freedom of expression, will apply when nation states are asking service providers to process data for them. And that, in this case, meant 2 different types of data processing. One was that in France and Belgium, they were asking these telecommunications companies, in most cases, to retain data for long periods of time, just in case either their police or the intelligence services thought they might like to use the data in the future. And then in the UK, they were going even further than that. They actually collected all of the data themselves from the telecommunications providers. The UK intelligence services did, and stored it. And in both cases, the Court of Justice had problems with those practices under European law.
And so just, again, me being the non-lawyer, I think I'm trying to make sense of this, and please correct me as I go. But so this is the Court of Justice of the European Union, which is the highest court in the European Union, which is separate from the European Court of Human Rights, which is a different court that just adjudicates on human rights. And so what's most interesting was that this was the Court of Justice of the EU, which traditionally has never really said much about national security matters because it's not traditionally in the jurisdiction of the EU. Is that correct?
That's right. That's right. So generally, we see that the EU has a carve-out, and it says that all of its member states can do their own thing when they're dealing with criminal law matters, when they're dealing with national security matters. But that changes when the member states are asking private companies to do something, in this case, telecommunications providers. And that's because the EU has decided through other laws like the e-privacy directive and the GDPR that they're going to put certain protections in place when member states are dealing with private companies and our personal data held by those private companies, or actually just communications data more broadly in the case of the e-privacy directive. And so this is now a relatively narrow area where actually EU law will apply, even though national security might be at issue.
And the specific powers we're talking about that were called into question, as you identified, there's the French and the Belgians were requiring telecommunications companies, so like basically ISPs and telephone companies, to retain data. And it seems, as ever, the UK decided to innovate on this idea, and to grab the data directly. Is that correct?
That's right. So the UK was still requiring the telecommunications providers to cooperate with them. But then, yeah, instead of just saying, hold on to this data, we'll come to you later if we need it, the UK just took it all. So they could run their own searches, do their own thing later.
Because the UK always has to be a little bit more batshit crazier when it comes to surveillance than every other country on the earth. Okay, that's just me. You don't have to agree with that.
No
So,
comment.
how did we actually get to the court? Like, why? Because I have to say, just to sound like the old man, the policies, at least in France and Belgium that you're talking about, I've been working on for almost 20 years. Basically, right before 9/11 was when the idea of forcing companies to retain data was first floated. And back then, it was a crazy idea. And then, of course, 9/11 happened. The Bush administration begged Europe to start doing this. And so Europe thought, well, maybe it's not such a crazy idea. And it took them years to actually deploy it. And now here we are, practically 20 years later, and the Court of Justice is weighing in on it. What got us to this point?
That is a good question, and a lot of different things. So you've actually taken us quite far back in history, but that is where it started, which is when Europe passed a data retention directive back in the mid 2000s. They instructed all the states to pass their own national laws, talking about how they would instruct service providers to retain this data. And that led to a series of legal challenges, which actually led to two earlier court cases, both decided by the same court, the Court of Justice of the European Union, which we commonly call Digital Rights Ireland, DRI, and Tele2 Watson. The first one coming out of Ireland, the second one coming out of Sweden and the UK. And in both of those two cases, the court pretty solidly said data retention, when it's general and indiscriminate, which is when the states were asking companies to retain all the data. They weren't just honing in on specific person's data because they had some sort of suspicion around why that person might be a suspect. That was not permissible under European law. But the way the CJU works is that it doesn't initiate cases on its own. Instead, the various member states' courts ask the court questions. And in this case, there were referrals from all three states asking the court these questions. Does EU law apply in the national security context? And then if it does, what are the safeguards that EU law demands when we're engaging in data retention or data collection? And so that whole process has, again, kicked off in 2015 in the UK, 2016 in France, and I believe also Belgium. And now we're here in 2020 with a decision. It all takes a while.
It sounds like that. And can you just talk to me about the data itself, and the type of power that is being questioned?
So the data itself is mainly communications data. And this is not the content of the communication. This is not when you're writing in your email what you're writing to your friend. Instead, this is the sort of who, what, when, and where of the communication, who you're sending it to, when you sent it, sort of what sort of device and where you sent it from, and also the details about who you're sending it to. And the court reiterated, which it had in those previous two decisions as well, that actually, even though this isn't the content of the communications, it's still incredibly sensitive data. It can tell us a whole lot about a person, knowing who they're in contact with, when they're in contact with that person. And therefore, it really requires the same level of privacy protections as the core content of the communication. And this is the type of data that typically is actually stored by these telecommunications service providers just in the regular course of their business, because of course they need to connect you to whoever you're talking to. But under those other European laws that I talked about before, the e-privacy directive, the GDPR, and the predecessor to data protection regulation, the predecessor data protection directive, companies weren't supposed to hold that data for very long. That was actually privacy protection. They should only hold it for as long as they need to provide a service to you because it is so sensitive. And yet, what the states were trying to do with data retention was to keep them to hold it for a whole lot longer. And that's when problems are caused.
Yeah. And okay, so tell me, like, how was it that the court was ruling this week? What was the journey for all these cases? So you said it was 2015 and 2016 in the UK and France and probably Belgium. What did it take to get these cases to the court this week?
So, beyond having the national courts ask the question, then we had briefing, which is we did our written submissions to the courts. Then we had oral arguments last year. That was in September of 2019, where everyone showed up in the court. It was a pretty neat experience, especially because so many states were interested in this. I think we had 20 plus countries and other representatives of other parties in the courtroom arguing about this case. So it was quite a large to do there. And that was in September 2019. And then after that happened, the Court of Justice of the European Union is a little bit different than some other courts in that they have an advocate general who issues a sort of preliminary opinion around how he or she thinks the case should be decided. And in this case, that opinion came out in January of 2020, and I think primed everyone to suspect that we would get a judgment somewhat similar to what we have gotten, which is one that especially said that EU law applies in this context. And then, of course, we got the final judgment earlier this week from the court.
And as a non-lawyer, I look at lawyers around court judgments, and I wonder, is this like Christmas Day for you? Is it like, oh my gosh, I can't wait, I can't sleep the night before, I got to find out what the court's going to say. You wake up and you're scouring the internet to find the decision. How does it feel? What's it like to do this and to read through? And how do you feel now that you've read it? Like, talk to me. Like, what was the day like?
That's a good question. Yeah, I mean, it is always a little bit nerve-wracking. We've obviously put so much effort, and so many people have put so much effort into the case that we are really excited to see what the judgment is going to be. What is the court actually going to say? So yes, we did quite a lot of preparation actually ahead of the judgment, knowing that it was coming. I think we had about week and a half notice that it was going to come out this last Tuesday. And so we tried to prepare, especially since in this case we had the Advocate General's opinion. We reread that and tried to get a sense of what the arguments might be and how the court itself might decide. But then, of course, on the morning we had to scramble to get the judgments themselves. And in this case, there are two different judgments, one specific to the UK and the other one focusing on France and Belgium. They're interrelated and closely connected and refer to each other. But then to add to the complication here, the UK judgments in English and the French and Belgian judgments in French. Eventually they'll be in all the different languages of the EU court, but right now they are just that. So we had to collectively read them using our different language skills and try to piece together what they meant. And that's always fun to do because we're trying to react as quickly as we can on the day to let others know what the judgment means.
And so as the picture became clearer, do you feel vindicated? Do you feel like how do you feel right now now that we have this clarity, or do we not have clarity?
Well, I think we definitely have some clarity, and I think generally we view the judgment as positive and a step in the right direction, or the judgments, I should say. But there's another step to go in this process, which is that, as I said before, these were judgments based on questions asked by the national level courts. So now all these cases need to go back to the national level courts in the UK, in France, and in Belgium to be applied by those courts. And so we actually don't know entirely for sure how this is going to change the law in each country because we need to wait to see what those national courts will say. So while this is quite exciting and really interesting to get this pronouncement by the CJEU, there's still some further steps before we can say that we've definitely finished the process.
Okay, the law moves slowly. This is not what I was advertised when I watched all the movies and watched all the TV shows about the law. But yeah, okay, we can take our time on this. So if we're going to take our time on this, can you talk through the core of the rulings, what we can take away from it as we await its implementation or the next stages in national courts.
Definitely. So, as I said before, one of the most important points coming out of the ruling is that whenever member states are asking service providers to process data for them, EU law is going to apply. And that means privacy protections and freedom of expression protections and all the other fundamental rights that are actually protected by the Charter of Fundamental Rights. And so that will have a big impact for a lot of actually countries, not just the three that were involved in this particular set of cases, but across the EU, because saying that EU law applies and then applying it in these contexts of data retention and data collection, what the court has said is that you can't do this in a general and indiscriminate manner. I'll put a few exceptions and asterisks next to that when it comes to data retention, because that side of the decision is more complicated, but said very clearly for data collection in the UK that you can't do this in a general and indiscriminate manner, which is what we often refer to as mass surveillance, where you're just collecting up everyone's data without any suspicion to think that you have any reason to think that they were involved in some sort of criminal activity or problematic activity. So that is going to be a new rule that all of the European countries are going to need to take into account, and they're going to need to look at their own laws, because especially over the last decade or so, I think mass surveillance has become a very popular technique, not just through data retention, but also in other forms of like collection or interception of content even. And I think the states may need to go back and think a little bit more about whether or not those laws now actually conform to EU law.
Just to pick up on that, like I think we need to recognize that governments have dramatically transformed their powers in the last 20 years. Because when I was growing up watching, learning about law on TV shows, the whole idea was that the state could interfere with your life in an investigation, in an active investigation. They should be able to get access to information about you if they suspect you. And what has changed is, as you say, this shift to mass surveillance, which is the state is interfering, or the state is accumulating power even without you being under investigation. That's a huge change. And so arguably, I think it's the courts catching up to that innovation. So is it fair to say that what's coming out now is, well, it's good news?
Yes, I think it is good news. I mean, as always, legal decisions have quite a lot of nuance to them. They're quite complex, but I think overall it's good news, is that courts are starting to grapple with these issues and try to put safeguards in place to protect us. Because, like you said, traditionally, the traditional conception we all have of when the state can get access to our private information in these really narrow circumstances when there's reasonable suspicion are what we still argue are required by the various fundamental rights and human rights frameworks that exist around the world. And yet, states have developed mass surveillance regimes without being tested under those frameworks. And now courts are starting to catch up and test, and in many cases find those regimes wanting, either because of the mass nature in the first place or because they don't have sufficient safeguards in place to make sure that that data, since it is being collected on all of us, can't be abused.
That's fascinating. Like, I just think back to the fact that this is a legacy essentially of 9/11, and not it's practically a legacy, as I mentioned before, of the Bush administration, which is Europe had this crazy idea of data retention, but never bothered to implement because they thought this would never fly. And then a few weeks after 9/11, George Bush himself writes to the EU saying, hey, if you want to help us fight this global war on terror, you're going to implement data. You're going to change your data protection laws, the very laws that protect people, and allow for data retention, and essentially opening the door to mass surveillance. And what's interesting is that in the US, at least, in the years that followed, there's been a reckoning, and there's been a political reckoning when it comes to surveillance and a legal reckoning with pushbacks. Even the 2008 election was very much like had a very strong element of debate around these types of powers. And there were numerous court decisions in the US. And then, of course, with the Snowden revelations, there's been legislative change in the US. And it's taken so long for Europe to have this moment of reckoning. And I don't get it, because when you step back and you read the news and you read the commentary, there's always this narrative that the US is crazy when it comes to surveillance powers and all of this, and look how terrible it is over there. But Europe, oh, if only, like, Europe is wonderful. It has its GDPR. Isn't that great? And what we're finding with cases like these, and when we dig beneath the surface, which is where PI lives, we see that the world's a much dirtier place. And surveillance powers are, well, every government on the planet is seeking these powers. But what's kind of shocking is that it takes 20 years.
It does. It does. I mean, yeah, I guess in the case of data retention, like you said, it really has taken 20 years. In some cases, it's been more like 5, 6, but it does take a while. Unfortunately, that's often the case with the law. It always takes it a little while to catch up with innovations in technology. And of course, part of what we do is try to make that happen a little bit faster. But courts are deliberative bodies, and they take a while to think about these issues, rightly so, because they're very important for our rights and our security, and need to be carefully considered. But I think that now we have a framework in place going forward that will be beneficial.
And can you talk through that framework just a little bit, so we can get an understanding of like what the judgments say about data retention, what they say about national security, what they say about analysis of the data?
Sure. So I'll take the UK judgment first. So, as I said, with regard to the UK judgment, it focuses on bulk data collection, which is what the UK intelligence services were doing. They were asking telecommunications providers to essentially turn over a large amount of data that they held on their users directly to the intelligence agencies, who would then store that data and access it based on some internal controls, but essentially as they saw fit. There was no independent outside authorization either for the acquisition of the data in the first place or for the internal use of it. And what the court said, first and foremost, is that when you're collecting all of the data from a service provider, that without sort of thinking about, is there a reason that I have to collect this data with regard to a particular person or a particular account, then that is general and indiscriminate collection of data, and that is a violation of EU law. And so that general and indiscriminate collection is no longer permissible. And among other things that you need to have in place in order to make it permissible would be not general and indiscriminate collection ever, but to make sort of a more limited collection permissible would be a clear law, publicly available. And that was one of the problems to begin with in this case, was that this was all done under these secret directives that were derived from a 1984 law, ironically.
Secret directives in British law, the country that brands itself as the land of Magna Carta, had secret directives.
Exactly. So no one knew until actually some of the oversight that became more robust post Snowden revelations. No one knew that this was even happening in the UK, even though it had been happening since the early 2000s. And this didn't come to light until 2015.
And I'm sorry, just to get really angry for a second, like I was in Parliament, in the House of Lords, constantly taking part in the what we thought was a national democratic debate, where across the political spectrum there were varying opinions, and eventually there was a relative agreement that the government was going too far, and so safeguards were implemented. And so the UK government then said, screw this, we're going to go to Europe and get a European agreement on this. So already the government circumvented the democratic safeguards by going to Europe and trying to get a European directive on data retention, which they then brought home saying, hey, we're being forced to by these big, mean Europeans who are forcing us to implement the power we've wanted all along. But look, we did that. We did all that democratic debate, And yet you're saying, regardless of all that, which all happened in the 2000s, you just said, nonetheless, in secret, they were going around that entire debate and getting the data anyways.
That's right. That's right.
That just pisses me off. Like, we could always say, oh, the courts and that whole process is anti democratic, we should have a national debate. We had a national debate. We had parliamentarians who, when we started the debate, had no idea what communications data was, had no idea how the internet worked. But by the end of the debate, they got it and they understood it was problematic. It was even in manifestos and election manifestos in the UK. So this thing mattered. And yet, beneath the radar, where nobody digs, because it's against the law to dig, we find that they had secret goddamn law. Sorry, I just had to rant. Oh, take it away from me, please.
No, I understand the frustration. And that's exactly why the court is putting in this rule in place, which is saying we need to have these sort of democratic debates around these powers. If you're going to use these powers, which are incredibly intrusive, they need to be spelled out on the face of the law so that we can have these democratic debates so everyone can understand what we are agreeing to. And that's what's necessary in a democratic society. And then that's the next question, actually, is then whatever the state decides it wants to do and puts in the law, that actually has to be strictly necessary because of the strong privacy intrusion that it involves, which means that it really has to be something that needs to happen because there's no other way, essentially, to collect this information. It's not just something that's useful, that might be helpful, but that is really necessary. And then on top of that, the third question is also, is this proportionate? Which is sometimes, even if something is incredibly necessary, it's still not something that we would conscience doing in a democratic society. It's just against our values. And an example of that, talking about that other court you were talking about very early on in the podcast, the European Court of Human Rights, has decided, for instance, that the UK is not allowed to collect DNA on all of us, to have a DNA database, because certainly that might be useful, but it's so incredibly intrusive that it would never be proportionate to do so. So that's an example of the proportionality analysis that now also has to apply if the state is going to try to collect large amounts of communications data.
So, what is the broader result or impact of this decision?
It really is a guide for all of Europe and arguably the world as to what is required when these types of privacy violations happen, which is if you're going to try to engage in mass surveillance, fundamental rights do still apply, and there are real limitations on what you can do. And that means that I think that a lot of different countries are going to have to take another look at their mass surveillance regimes and hopefully cut them down and make them much more reasonable, and also make sure that there's a legal basis for what they're doing and that they've had that public debate, which is so crucial in democratic societies.
But if I could, being executive director of PI and having to be up close to the law as it goes through its iterations, I wish this was the moment in the movie where we pop the champagne, socially distanced, and we say, "Hey, battle is won. Let's move on to the next thing." The reality is, the law is not self-executing. It takes people. It takes people to make sure that the court decisions get sent back down, that the courts nationally take the next steps, that the governments don't create secret law again and ignore court decisions as they have been known to do. There's a hell of a lot of work that's still to come, right?
Certainly. And as you described that, it makes me think again back to when we were sitting in this courtroom back in September 2019 with 20 plus states and all of their lawyers arrayed against us. And the claimants in these various cases were almost all civil society organizations and NGOs who are obviously much smaller and less well resourced. And these are really important big fights that we are taking on, and we're proud to do them, but it does take a lot of effort and a lot of our time.
and as you say, like in that court, you had so many governments with their deep pockets, with their esteemed lawyers, with charging remarkable amounts, defending the powers that the state wanted and that the state wanted to keep secret. And then there was all these little NGOs taking on this incredible power of the state, not just the power of the state to do surveillance, but the power of the state to marshal the resources to try to defend their powers when scrawny little people like us call them into question. And I just got to say, like, I don't say this often enough to the lawyers at PI that we work with, but what you have to do and the types of fights you have to stand up against, and the Goliaths, let's say, it's incredible that we have won so often, and we've made ground so often, considering the everything stacked against us. So congratulations. Like, just take a bow for a second. I know you don't, and I know it's not like the movies, but like, it is pretty cool to have a court, like the highest court of the European Union, going through our arguments and saying, huh, you know what, I think that little NGO in London actually had some good points.
It is. It is pretty neat. And I must give due credit to all of our amazing outside counsel, our pro bono lawyers in most cases who work with us too, who do an amazing job. But yeah, it is pretty neat that we are able to have this impact. And I think that's one of the wonderful things about the courts, is that you can take these fights to them. And if you have the better legal argument, then you can win no matter what level of resources you have, as long as you have enough resources to bring the fight.
Yeah. So we don't at PI, we don't try to hide or gloss over how hard this is. So if you do want to see the complexity of this case, you have to come to our website at privacyinternational.org, and under the section for legal action, you can see whether it's this case or the many other cases we're taking. You can see in great detail all of our filings, all of our findings, and all of our analyses, and you can see the amount of work that goes in to the hope that a bunch of senior judges will ultimately agree with us that we have a point. And so doing all that work, and so while I'm directing you to online resources, doing all that work is hard. This took years. And even when you win, you still have to take it to the next step. And even when you get past that step, they might try to circumvent you in another step. It takes constant vigilance. And so I would, if you want to know more about these types of stories of our cases and follow us as we do these, go to our action.privacyinternational.org resource, where you can sign up to get news about what we're doing as we're doing it, and then our analyses after the fact. And we're so lucky, as Caroline mentioned, to have our pro bono counsel who work for us for free, but there are still extraordinary costs that go into all of these cases. And we're a charity with limited funds, so any support you can give us through a donation would be very much appreciated as well. You can go to support.privacyinternational.org and donate to us there. So, yeah, Caroline, thank you for joining. And again, thank you to you and all of the people who have been involved in this case. It's been a journey, and I look forward to the next steps.
Thank you. Thank you so much, Gus. It was my pleasure.
And thanks to everybody for listening. You can get involved with this topic, as we say, by visiting our website, joining our mailings, and you can always contact us as well. And you can like and subscribe to this podcast on the various platforms you use. And it's also available from on our website at privacyinternational.org. We're also on Twitter, Instagram, Mastodon, YouTube, and Facebook. And thank you very much for listening. The music is courtesy of Sepia and Glassboy, which is licensed under Creative Commons.